So welcome to the Renters' Rights Bills and HMOs, what you can do, brought to you by the HMO Action Group. A very exciting moment in time. And we're going to talk to you about what we are a bit later on, but also the impact of what the Renters' Rights Bill means for you and your tenants. So what are we going to be doing? Well, first of all, we're going to introduce the panel. You're very fortunate to have two of the three that are here tonight. So you have me, who's starting us off tonight, and then we've got Wendy Whitaker Large. Say hello, Wendy. Wendy's in a monologue.
Hello,
Good.
Wendy.
Hello, Wendy. And we've also got Alan Murdy, the legalese extraordinaire. Say hello,
Hello,
Alan.
good evening, everybody.
Yes, so yeah, the three of us, myself and Wendy, are HMO investors and coaches, mentors, and developers. And Alan is the nation's foremost legal expert in council tax. And to be fair, is just an absolute whiz at understanding how legislation and policy works. So we're going to introduce Alan for his thoughts on everything that's going on at the moment a bit later on. But we're going to start with an overview of the Renters' Rights Bill, some of the implications there, and then we're going to move on to what it means for HMOs specifically, and then we're going to go on about what we are doing about it. What is it that we, as the HMO Action Group, are doing? And since we were formed back in 2021 under our previous pseudonym of the HMO Council Tax Reform Group, now the HMO Action Group. So what is it that we have done? What is it that we are doing? And then how you can get involved as well. We'll also have time for a little bit of Q&A at the end. And then we'll keep it brief, we'll keep it to the point, but we will make sure that you guys go away more clued up about what is about to happen to our industry in the next 3 to 6 months. So, key points. There are 10 key points that we as a group have identified that are quite problematic across the board with rental property. So the first one is that the assured tenancy, the short hold tenancy is disappearing. So that tenancy agreement will no longer be valid. Essentially, we will have a periodic agreement from day one, where the rent period will not exceed a month, which means that we can no longer have rent being paid every 3 months, every 6 months, every 12 months. Rent in advance is now technically not possible through the Renters' Rights Bill. So, point two, point one and point two are the same. Essentially, point three, rent to rent head leases will be periodic as well. So this is going to be a problem for those people that do operate in the rent to rent space. I personally believe that rent to rent as a strategy is going to get very tricky, very difficult, and only the best operators will be able to survive and thrive in this market. It will no longer be an entry point for property, I believe. Point four, statutory procedure for increases of rent. So there is now a process where we will need to serve notice. It's not the same, but it is the same as we do now, which is the Section 13 notice. But we're going to have to do this in order to increase the rent in writing. And there will be point five, which is the ability for the tenant to challenge the amount or that increase of rent as well. And one of the most frustrating parts of this is that, let's say you want to increase the rent to market rent, which you are allowed to do. And then, yes, when you say point two, Section 21 is being abolished. That is a very good point. It's not on the list, Wendy, but there we are. It's
Well,
effectively.
actually, it's not even in the bill. That's why. What they're doing is they're doing it the other way around. They're not abolishing Section 21, they're abolishing short hold tenancies. And by dint of abolishing the short hold tenancy, you therefore get rid of Section 21. Because actually, the Renters' Rights Bill is not really a new bill. If you read it, it's actually editing previous landlord and tenant acts, and I'm sure Alan will go into that later. But actually, the actual process is to get rid of, if they want to get rid of Section 21, how do you do it most effectively? Get rid of ASTs, and then you can't have a Section 21. So that's why it's there. But yes, sorry.
That's a
Carry on.
fine. No, that's why we're all here. So essentially voids that particular way of getting people out. Coming back to the increase of rent. So when we have the increase in rent, the tenant would be once a year, you can put up the rent using a Section 13, and that allows us to be able to put the rent up to market rent. But the tenant can challenge that. They can challenge the amount that they're being asked of, and they can take it to tribunal, first tier tribunal, and then the judge may agree with you that the rent rise is reasonable, which I think it probably would be in most cases. But what it has meant is that in order to get to that tribunal, which may have taken 2, 3, 4, 5, 6, 9 months, the tenant is paying the old rent, and the judgment now would say, yes, you can increase the rent to this, and then that takes effect from the date of the judgment, not from the date of the appeal from the tenant. So they can be sat on this lower rent whilst, and then you're going to get a rent increase, but it's going to take a long time. So that process is something that I would be looking to avoid generally. And point 6 here is the right to request permission to keep a pet, so non-discrimination about pets. I'm not putting a pet in an HMO. Just, I don't care what anyone says. I'm not putting a pet in an HMO. I think there's plenty of it, depending on what pet. Goldfish, maybe. Cats, dogs, absolutely not. I think there's plenty of reasons that a judge would take, pity on us and the other tenants that may well be allergic to those dogs. Then number 7, prohibiting rental discrimination for universal credit or childcare. That is very important to ensure that we're not discriminating against people of certain circumstances. As you come on, you'll see that I'm not too concerned about this, because the demand for what we create is just going to increase, means that we can pick and choose regardless of they're in universal credit or not. So it's going to be easier for us to choose tenants. There's the introduction of an ombudsman, which one you'll go through shortly. The database requirement, which, to be fair, as I said to the guys before we started, if they can create something which is as straightforward as an MOT, and the way that is tracked and managed through an online process, that would make sense. Because a car is a dangerous, it's a weapon in the wrong hands, and it is dangerous if it's not well maintained. You could view the house in exactly the same way. It is dangerous in the wrong hands, and it needs to be well maintained. So that's my kind of analogy for the database. Whether it actually does that is another matter. And then we also have the decent home standard. Wendy, this isn't new, is it? Decent home standard? No.
No,
So
but this has been applied to the social housing sector first,
yeah,
and not in the private rental sector as yet, but they want to bring it in for the private rental sector.
and this is probably one of the most under. Well, there's this and the Fit for Human Habitation Act, which is probably I was at dinner with Ben Beadle on Friday night, and we had a bit of a quip about that. This is the most underused piece of legislation in the country, the Fit for Human Habitation Act, which is the most underenforced, underused piece of legislation out there. So, a lot of the rules that they're bringing in is not that different from what already exists. There are ways to use existing legislation more effectively to get to a similar point. So what do we then have, really? Wendy,
Okay, so I think some of the big points. Thanks very much, Matt. That was great introduction. So some of the big points I think that you've probably seen, many of us have seen on other social media or in the news or in other periodicals and magazines and so on, will highlight some of the points we're going to make tonight. And I'm sure many of you are very well educated about some of these already. But what we want to particularly focus on is how this will affect the HMO industry, because we can see some real unintended consequences with this piece of legislation, or this rather piecemeal legislation, that does not think about how this will affect HMOs. And there's some very big unintended consequences here, which I think are serious, which is why we as the HMO Action Group want to raise those as issues, and be, if you like, be shown to understand them, because there may well be a time when the implications of this bill start to become reality. And we want to be there to say to the government, yeah, we did kind of warn you about this, and this is what we think could be the solution. And I think it's very important that somebody is the voice of the HMO industry. So you will have, of course, heard that tenants have to give the tenancy is going to be periodic from day one. However, tenants have to give 2 months' notice to quit the tenancy, to leave the tenancy. Now, they could serve this from the first day of the tenancy, and it could be served in any way, including text or WhatsApp message. So, in terms of shorter turnover, if you like, or shorter tenancies, this is something that, of course, has really caused a lot of people to be very, very worried, because in HMOs, what you ideally want is somebody who's going to stay for maybe a year and a half, 2 years. But of course, even if you do get a more regular turnover, what I could see happening is that you'll use that as an opportunity to put up rents. Why wouldn't you? And when it comes to, of course, the ombudsman, and again, this is where we've looked at some of these details and sort of gone down the rabbit hole. The ombudsman, not the rabbit hole, the ombudsman will be judging your rent if you got a challenge by the market rent. Well, what's better than a 6-bed HMO with 5 rooms being rented at £700 a month? And this room that you've maybe it's been rented out for a long time, you now put it up to £700 a month. How is that tenant ever going to justify the fact that their rent is not at market level, because all the other rooms in that house are at £700 a month? So actually, there's some really kind of interesting factors that just have not been considered in this bill, that HMOs have got a distinct advantage. So that's one thing about tenants leaving. I don't think that's necessarily going to be a problem. And actually, when we look at the statistics, again, I think you'll be reassured, and it'd be interesting to know from you guys on the webinar tonight, how long your tenants normally stay. Do you have regular high turnover of tenants? Because the statistics we see, that's not happening. Now, what happens though if you do want to evict a tenant? Well, the mandatory threshold for eviction will increase from 2 to 3 months in terms of arrears. So the tenant will have to be 3 months in arrears before you can even start any possession action. And also, you will have to give the notice period. The notice period will have to extend from 2 weeks to 4 weeks. So this is doubling up the length of time before you can then escalate it to court. Obviously, at the moment, under a Section 8, you can serve a possession notice, and then 2 weeks later, you can escalate that to court. That doesn't mean to say it will be heard in 2 weeks' time, but it simply means that you can escalate it through possession claim online, or you can fill out the paperwork and go to your local court and get it heard. So the actual Section 8 eviction time for tenants being in arrears is going to increase. The other thing, though, that's quite interesting is the number of grounds that have been added into Section 8. There's a few extra grounds in Section 8, which we haven't got time to cover tonight, but I think this would be a little piece of homework. I would suggest go and have a look at which Section 8 grounds there are, because again, I think there's some unintended consequences of some of those grounds. For example, one of them is that if you intend to do a refurb, you can give your tenant 2 weeks' notice. Now, in HMOs, if you have a high turnover, or if you have regular, you have lots of people living in that property, you might need to do a refurb of a room. You've got a justified ability to evict somebody in 2 weeks if you're going to do a refurb of a room. So have the government thought about that? I don't know. Have they seen that is an unintended consequence? Have they thought about how this bill can be read as an HMO investor or landlord? Now, the third point here is that tenants will benefit from a 12-month protected period at the beginning of a tenancy, during which landlords cannot evict them to move in to that property themselves or to sell the property. And in fact, there are quite serious consequences if you end up claiming that you're going to sell or move into the property, and you give the correct notice, and then you decide, oh, actually, I've got rid of the tenant. Great, I can now re-advertise that property for let. you can land yourself with quite a hefty fine if you do that, and various other consequences. So that's quite that's going to cause some people who are possibly thinking about selling to not even want to rent out their property from the beginning. Though, and there might be landlords with HMOs at the moment who've got an HMO, let's say it's a 5-bed HMO, and a couple of the tenants decide to leave. If they're in their minds thinking, do you know what, I'd like to sell this property anyway, they might not choose to refill those rooms because they know that they're going to have to wait 12 months plus the notice period before they can get rid of that tenant. So it's possible we'll again start to see the volume of HMO rooms decreasing. Well, for those of us who are not planning on leaving the market and not planning on selling up, this could be very good because less supply, that means prices are going to go up very, very likely. Yeah, so that last point is really about selling the property, what I've just talked about. So that's something to be aware of. Is the Section 8 will be the only methodology you'll be able to use now to evict, and it's worth just having a look at that in a bit more detail to understand what that might mean for you. Now, they are introducing a new student possession ground, and this will require prior notice from the landlord and only applies to HMOs let entirely to full-time students. Now, this is a little bit of the government trying, I think, to amend the initial horror that was felt when the bill was first announced because of the impact on student HMOs. Now, I don't think it quite goes far enough because ideally what we really need is a fixed term tenancy for students, because otherwise it's still very uncertain for the student, particularly if they not being in that HMO for a set period of time, especially because many students have joint and several liability tenancies, which means that they rent with a group of students, they all share the bills, they all share the responsibility for that property. And what that means is that currently, if a tenant decides, oh, they're sick of university and they want to leave, the group of students, it's their responsibility to backfill that person into the house. That means that they get to stay in the house, they get to keep the rest of them keep their rooms, they can keep living there. The landlord gets the rent that he or she wants, and everybody's happy. But in the new renters' rights bill, if one of the students leaves, effectively that completely destroys the whole joint and several liability tenancy, and they will start again from the beginning. So although the grounds for possession allows student landlords to regain possession, it doesn't necessarily protect tenants from being evicted, and they could be evicted halfway through their term or halfway through their academic year. So this is again quite a serious impact, and we want to really help people to understand what this might mean and what alternatives might be for them to, if they still want to carry on providing student accommodation. Now, another area that we feel very strongly about is the antisocial behaviour rule. So I'm not going to go through all of this, it's very wordy, isn't it? But the point is that in the new rules, and this is how it's written. So this is the actual quote from the legislation. And you can see here that what they're doing is they're altering other pieces of legislation. So in the 1988 Act, in section 9A, in subsection 2, after paragraph C, insert and that's how the bill has been structured. It's a piecemeal bill that just kind of edits other different bills. So there is a ground to evict tenants on antisocial behaviour. One of our arguments is this going to be sufficient for us as registered landlords? I mean, many of us, have got licensed HMOs, so we are already fit and proper people. We would argue that actually we should be allowed to make a sound judgment about behaviour of one of our tenants and make that choice to evict them under a ground 8 for antisocial behaviour, and do it quickly. Because if you've ever had antisocial behaviour in your HMO, it really badly affects the other tenants, doesn't it? It's the other tenants who are often affected. They're the ones who are phoning up or emailing or complaining or getting upset. It's not the person who's antisocial. For them, it's water off a duck's back. So not being able to get rid of an antisocial behaviour tenant or not being able to do it quickly, I think is a bit of a risk in the new bill. Now, of course, if you ever had to go to court for this, there are paragraphs within the bill that sort of explains how this will be managed, and basically the bill expands the principles that judges must consider when they're making that decision whether to evict under this discretionary ground for antisocial behaviour, and they have to give weight to the impact on housemates within HMOs and whether the tenant has engaged or hasn't engaged with other interventions to manage their behaviour. Now, I think there are two mentions in the bill of HMOs, and that's one of them. But is it sufficient? That's the question. Right, another area is about rental increases. So Matt mentioned this at the beginning. This is one of the key areas, of course, that at the moment you can give your tenant, an informal notice to say you're going to increase the rent after the initial AST has expired, and you, by way of agreement, you can agree to increase the rent to a certain level. You will only be able to do this under the Renters' Rights Bill once a year with a Section 13 notice, and you can only serve it once a year, and 2 months' notice will be required. At the moment, 1 month is needed if you're doing it in a very, in an informal way. But under the Renters' Rights Bill, you have to give 2 months' notice. And as Matt mentioned, a tenant could immediately complain to the Ombudsman and say, "Oh, that's not fair." In which case, until that case is heard and agreed, and the next rent has come around, you won't be able to you won't be able to set the rent at the new level, whatever has been agreed under the Ombudsman. And you won't be allowed to raise rents. Sometimes landlords will increase a rent because they don't like the tenant. They don't want to go through a Section 21 or a Section 8. They just want the tenant to sort of get the distinct message that they are no longer wanted. Well, a great way to do that is simply to increase the rents. But that will be not allowed under the Renters' Rights Bill. What market rent is, though? Well, again, we could be here all day discussing what market rents are. So the Ombudsman will kind of, be the person who will negotiate, navigate, mediate on this particular matter. And for the honour and the joy of being listed with an Ombudsman, landlords will have to pay a small annual fee to the Ombudsman service. This is whether or not you use it. Okay, so this is just in case you thought that Rachel Reeves had stopped taxing people. Let me tell you, oh no, there's a few in the back door taxes, and this is one of them. The Ombudsman you'll have to pay for it, pay for the pleasure, and you'll also have to pay for the pleasure to be on a new database. So in addition, you'll be on a database to officially be able to rent out your HMO. So this is in addition to being on a licensed database. And the Ombudsman will have rules, be able to consider complaints on a wide variety of matters, but only tenants will have the opportunity to seek redress from the service.
Okay, before we go on, I just want to add something about that, the market rent. One of the things that I think is a benefit to having an HMO which is rented by the room is that the people are going to move out at certain times, and when a new person moves in, you're advertising the room at market rent. So the market will determine how much you can rent that room for. So within the property, you've got a microeconomy of different rentals. So when you're going for your Section 13 to increase rents, because on the whole, I don't normally increase the rents on HMO rooms. Yeah, they might be there 1 year, 2 year, 3. It's not something that we actively do like we do on a buy-to-lets in the same way, and something which has been brought into the forefront because I think we now will be increasing the rents every year to match probably the most expensive room in the property that has been most recently rented, because that is the market rent for that property. And you have the evidence, you have the tenancy agreement saying, well, that's what that person's paying in the room which is identical next door. So there are some benefits there.
Yeah, totally, Matt. I totally agree. This is where there are some benefits to having an HMO, because you've got evidence you could take to the ombudsman and say, well, hold on a minute, I've got 6 rooms rented out at 750. This tenant's complaining that I've raised their rent to 750, but that's market, because in this little micro market, I can demonstrate that. So yeah. Now, one thing that people perhaps haven't quite realised is that the bill will be introduced in one fell swoop. We should get notice of when that happens, but it's not going to be introduced in a gradual way. With the Renters Reform Bill, which was the Conservative version of this, they had said that anybody who was still on on an assured short hold tenancy, or a periodic tenancy that had come from an assured short hold tenancy, would still remain within that kind of legal framework. But with the Renters' Rights Bill, the Labour government have said that on day one, when the bill is passed and introduced, everybody will immediately move to a periodic tenancy. So that's something to think about in terms of your own processes, your systems, your admin. If you're managing your HMOs, have you thought about that your tenants will go immediately onto a periodic tenancy from day one? And what impacts will that have? So if you've just signed somebody up onto a normal AST, and a month later the bill is introduced and passed, you'll have to put them onto a different form of tenancy, because that original tenancy that you set them up on will no longer be in existence. It is going to be made null and void. That's what they have stated will happen. Now, there is, of course, a couple of implications here for HMOs, rent to rent. Just put your hand up, or say why in the chat panel if you do rent to rent. Anybody here tonight doing rent to rent? Mark's doing rent to rent. Thank you, Mark. Anybody else doing rent to rent? I can't actually see everybody's hands. Sam's doing rent to rent. Okay, so probably you have maybe looked at this already. If you haven't, we'll describe what the bill is saying. So, because there are no longer going to be fixed term tenancies, and therefore Section 21 evictions will no longer be possible, vacant possession will not be guaranteed at the end of any rent to rent agreement. So that's something to think about. How do you manage the end of that rent to rent agreement? Because it will be more difficult to ensure vacant possession if that's what you have agreed with your superior landlord. And the bill is also going to extend rent repayment orders to so the liability of rent repayment orders to superior landlords. Now, again, that's quite serious for the superior landlord. Do they know that? And the question will be, to what extent are you going to make them aware of that? So this means that if you, as a rent-to-rent operator, commits an offence, such as not licensing a property where you should do, or continuing to offer fixed-term tenancies, the superior landlord will be pursued. They can now be pursued by the tenants for up to 2 years' rent for you as a rent-to-rent operator's failure. So I think some superior landlords may well get cold feet and not want to do rent-to-rent anymore. So again, this is something that's going to have to be discussed and debated within the rent-to-rent community. It's not something I'm an expert on at all, but I know there are people who are thinking this through and what this might mean and how to try and mitigate some of the risks of that superior landlord. And it overrules a Supreme Court's decision in Rakusen versus Jepson, which determined that rent repayment could only be made against an immediate landlord. So that's a change in the bill as well. We talked a little bit about students as well. Again, the result of the bill basically means that because students can give notice from day one of their tenancy, and the other students will be, left to sort of flounder, and because effectively the tenancy will end, there's more likelihood of landlords having empty student properties and then probably saying, oh, I'm going to turn it into a professional HMO. Why wouldn't I? Or it's possible that landlords will give notice to all the other students as soon as one leaves. So there's going to be much more uncertainty in the student market. And I know this is beginning to ripple through to the student community. Already there are some big student groups across the UK who are really trying to change this and how it's implemented. And it's interesting because we'll talk about the passage of the bill in a minute. I'll ask Alan to cover that so you can see where we're up to, because we're kind of past a lot of the deadlines by which we can make our views known about the bill. But let's see. I still think there's there's some opportunities there. Professional HMOs. So again, we talked about giving 2 months notice to quit. So that delays their ability to leave and move on sooner. So I see this from the point of view of the tenant's angle here. If you're a tenant in an HMO, let's say you get a new job and the people say, can you join us in a month? And you go, yeah, that's fine. I can give notice to my current employer. I'll move up to Birmingham in a month's time. And you message your landlord and say, I've got a new job, I'm moving to Birmingham in a month's time. And the landlord goes, well, you can't, you've got to give me 2 months notice. What? Oh yeah. It's in the contract. You can't give 1 month, you've got to give 2 months notice. And if you don't give me 2 months notice and pay me 2 months rent, I'm keeping your deposit. Oh, I didn't know that, but I need that deposit so I can move into my new house in Birmingham. Tough. You've got to give me 2 months notice. I think that will be very painful for tenants who don't realise they have to give 2 months notice. And I think it's going to really clog up the HMO market. It's going to slow everything down. And it's potentially going to slow down the jobs market as well, because a lot of tenants who live in HMOs live there so that they can move relatively smoothly and quickly. Deposits cannot be increased to cover the loss of rent if the tenant leaves without paying in the last 8 weeks, because deposits are going to continue to be capped at 5 weeks rental. So let's say your tenant who's moving to Birmingham suddenly says, okay, thank you very much, and leaves anyway. And maybe you've got 1 month's worth of rent, or maybe you've only got 1 week's worth of rent, because some of our tenants pay weekly. That tenant goes, you may be taking a maximum of 5 weeks deposit. So you haven't even got enough money to cover that potential void. Now, it's true to say there's no reason why you couldn't re-let that room. But the point is that you may not want to re-let that room while you're still in that 8-week period. And because there are pros and cons to doing that. So I think there's going to be some differences in turnover in HMOs. I think that some tenants are going to be disappointed at how much notice they have to now give. I think tenants might be disappointed as well about the increased need for bigger deposits potentially. You know, we might now start to ask for 5 weeks worth of deposit. We don't do that at the moment, but maybe in the new world we will. I also think that there's going to be much more demand for guarantors in the new world, because you're going to want to know that if your tenant does leave early, you've got another way of getting back the rent that they were due to pay you for 8 weeks when now they've left after 4. And the other thing is, of course, that I think there's going to become a lot of HMO landlords who will go, do you know what? Now that the holiday let scheme, the furnished holiday letting scheme, which wasn't actually ever a scheme, it was actually a business. But anyway, nomenclature aside, the furnished holiday let scheme is now going to be taxed at the same rate as an HMO business. Maybe I'll just turn my HMO into a short-term let. I'm not going to do HMOs anymore. I'm not going to do long-term lets. I'm just going to do short-term. Who knows? But I certainly think there are people considering how do they navigate this with their business and make some changes. So again, unintended consequences here. Right, just a couple of quick statistics, because I think it's useful to see what the market is saying. Younger households are more likely to expect to move in the next 6 months. So where did I get this from? I can't really remember now. I think it was from the English Housing Survey. And when asked about this, and these are obviously, you can see the blue ones, the navy blue ones at the top, these are owner occupiers. The middle ones are in the teal colour. They are private renters. So you can see 20% of private renters who are younger households are much more likely to move than any other age group. So again, that very much reflects the kind of tenant demographic that we are all probably dealing with in our HMOs, although we may have older tenants as well. But interestingly, in the English Housing Survey from 2022-23, that's the latest one, the average length of stay is 4 years and 4 months. Now, that's admittedly for single buy-to-let properties rather than HMOs. But nevertheless, I think it shows that people are staying longer in properties, and they are, they're wanting to stay longer for many different reasons that we know about. So I think those statistics should help us, but that's not the only thing that I think you should be thinking about in terms of what's going to help you to navigate the Renters' Rights Bill. Matt, over.
Yes, so a bit. So Wendy, yes. I think there's a key thing here to note is that just to follow on what Wendy's saying is that rents are still increasing. I don't see any world where rents are going to decrease dramatically. If anything, they might flatline temporarily. We do have other economic factors at play here. We have stagnation in wages, which will affect rent affordability, but we also have decreasing supply of rooms, and with room rents, we've lost almost 10% of our HMO stock in the last 6 years. That's massive. That's an absolutely massive number of rooms that we've lost, and and we're losing about what's this about 30, I'm trying to remember the numbers now, about 40,000 rooms a year that we're losing. So it's a big deal. That's assuming a six-bed HMO. So rents are continuing to go up. And if you're concerned that this is going to have an impact, I'm not too concerned. If I was a student landlord, I'd be more concerned, and I might be considering my options. But I do work with people and clients that are working on larger purpose-built student blocks. So they're pivoting into parts of the market which are maybe deemed to be slightly different to the rest of the HMOs. They're still looking at the same tenant demographics. And ultimately, it comes down to people's understanding of what's out there, because the HMO action group, the whole purpose, the whole reason that we decided to reimagine ourselves from the council tax reform group, because firstly is because we got results. We were able to win on that campaign, and the reason we were able to win on that campaign is because we had a strategy with one singular aim, and we were able to get people to listen. And that's what we're going to do again. We're advocating, and for landlords, there isn't really anybody, any group, any organization which is lobbying really for the interests of landlords effectively. There are some other organizations out there, much bigger, that look at the property market in general, but especially when it comes to HMOs, nobody cares. And I have, on a number of occasions, chatted to people in those other organizations who say we're pissing in the wind. Pardon my French. Literally, the words were pissing in the wind, trying to get any changes to associate with HMOs. And I think the reason why we can get change is because we will campaign on a singular issue, not every single issue. It's worked before and it will work again. So we're going to advocate for you guys as HMO landlords, as tenants, as rent-to-rent operators, as managing agents, letting agents. We're going to advocate for the voice of the HMO industry, and we're going to campaign. And we're going to campaign. We generally campaign in three ways. We campaign in the media. We campaign with legal battles and legal precedents. That's where Alan comes in. And then we also campaign through connecting with legislation, so proposing new legislation, pointing out the errors of what they're doing, and what we're going to do is we're pointing out the errors of what they're doing, and we're going to track it, and we're going to show them that this is what we said would happen, this is what's happening, and this is how you can solve it. So over the next 5 years in this government, we're going to play a big game of I told you so. To be fair. But right now, it's to get them to listen, and we'll show you what we've achieved so far. And then we're going to educate, because if we're going to educate the market, a lot of people don't really understand it. Some of you here may have been contemplating leaving the industry, shutting up shop, changing strategies, doing something different. Whereas in reality, depending on what type of property you've got, it might not be that bad. And if it's not that bad, then what are the real issues that are going to make an impact? I think the majority of this is actually going to benefit my business, but it's going to have a bigger impact on the tenants than it will my business, which is the complete opposite of what the government are talking about. So this is why the HMO Action Group exists. And Wendy and Alan were founding members of the Council Tax Reform Group. I've been a member for a couple of years, and we have rebranded, we've renamed ourselves the HMO Action Group as of now, essentially. And we're starting to put together our strategy, and we're starting to put together how we're going to make this happen. Next slide, please. There we are. So to date, what have we done? Well, in our former under our former name, we achieved the legislative change on room bandings for HMOs. This issue, which was impacting massively landlord businesses, letting agency businesses, and more importantly, tenants, where a room was being separated into individual units for council tax purposes. It is now illegal to ban an HMO. If it's an HMO under the Housing Act, it's illegal to ban it as well, you have to ban it as one property. You cannot split it up. That is what the law states. And that is what we proposed a variation of this, that Alan wrote, that was submitted into the Levelling Up and Regeneration Bill. And then it was taken out of that and then made into a regulation signed by Michael Gove. So that's what we were able to achieve. And on that journey, we were able to attain press coverage on the topic. We were able to get, which papers were we in through Darren and others? We were on GB News, we were on the Daily Mail,
Daily Express, the Telegraph, Sunday Telegraph. Yeah, we got into a number of them.
Exactly. So we have some good contacts with journalists that are interested in what we're talking about and want to listen. And then we also, through the work that Alan has been doing on some test cases, we've been mounting legal challenges on that particular topic of council tax. And that is work that we are still doing to this day, because there are still some legacy issues with this from the 1st of December 2023. So now over a year ago, the legislation changed, but there are still some issues with backdating and that we're working on, and we're helping landlords and tenants guide through. When it comes to the Renters' Rights Bill, what have we done so far? Well, we've done letter campaigns to MPs explaining the issues. So we've been we've been whipping up support through our networks that we have between us to get multiple letters sent to MPs explaining the issues. We've had meetings with multiple MPs as well. Wendy and myself actually met probably just about 3 weeks ago with MP for Northampton South. He was surprised by some of our comments and was like, I thought this had been covered in the bill. I thought this had been covered in the bill. And I think a lot of MPs don't know what they're voting for. They're just being told to vote for it. And so this is why a government is made up of individual members of parliament. Those individual members of parliament may vote and act as one, but they're all individual people with individual constituents that have individual problems. And all we need is a number of those to start to bat for our corner, to then start to whisper in people's ears. We've done it before. We will do it again. And then we're reaching out to press to share the impact and the problems this will bring. So we're going to highlight what is going to happen. We will highlight the potential problems, and we're going to document it. And when these things start to happen, we're going to refer back to what we talked about, what we said we were going to do. And we've been in the press before. We've had media coverage. It has shaken things up in government, and we will do it again. So the HMO Action Group, how can you help? How can you become a member? Well, we have a campaign that we're running towards the end of this year, which is about creating our 100 founding members to lobby together. We are already 30% of the way there, and we haven't even, this is the first time we've spoken about it in this format on a webinar or a workshop. It's been word of mouth just over the last week. We're 30% of the way there. So to become a founding member, use your phones, your QR codes, and dig out your phones and go to that link, and it will show you exactly how to join. At the moment, we are building a membership portal. Until then, we have a GoFundMe page, which is the same GoFundMe page we use to raise funds successfully for the council tax reform group. And for the first 100 only, the 100, I'm going to call you, the 100 founding members to become a member of the HMO Action Group, it is just £99 for that first year. After the first year, and once you've hit the 100, that membership fee will increase. And if we compare that with other bodies, yes, there are other larger bodies that may provide some extra value as well. But which larger bodies or which body actually got legislative change for HMO landlords? That was us. So,
Absolutely. And I think it's really powerful, Matt, because anyone who joins, not only are they supporting themselves through education that we are going to provide and provide more of it for them, but also they're part of a group of people who are actively investing in HMOs. Unlike a lot of landlord bodies, the people in charge aren't themselves landlords. We are. We have excellent legal support already through Alan and also his network. And we are vocal and forthright about HMOs. So people know if they join us, they're getting a group of people who are committed to making their voices heard, to representing them at the highest possible levels, and to implement change, to action change in the industry, not just in the HMO industry itself, but at higher levels of government, to enable them to be effective operators and to be able to navigate the changes that are possibly on the horizon for them. We want to make it much easier for you to do that. And we want to make it much quicker and faster for you to find the information that you need. So that's why we're launching this. We only actually launched it a few days ago, and we've already reached about 35 members. So we are well on our way to getting the first 100 members join up. So I would absolutely emphasize what Matt has said tonight. If you haven't already joined, it's only £99. It will go a long way because we're all volunteers. It will go a very, very long way to helping us to achieve our aims. The QR code is there. Please link to that. Please go to that page, pay your £99. We will then acknowledge it and bring you into the group, and you shall be an official member of the HMO Action Group. Thank you, Matt. Right, now I'd like to bring in Alan Murdy, who, as Matt said earlier, is our solicitor, well, barrister, sorry, I should say, is a barrister, although he's a very, good legal background. And as many of you know, Alan is the foremost expert on council tax in the UK, and he has written 13 or maybe 14 volumes of quite a serious publication, Alan, published by the Child Poverty Action Group. An excellent publication. I have it on my shelf behind me, regularly refer to it, I have to say. Absolutely excellent.
But hours of unlooked for pleasure in that book.
Yes, quite. But Alan, we'd really like your thoughts on the Renters' Rights Bill, because I know you've been giving it some thought. What are your thoughts?
Well, indeed. And let me say, just first of all, ladies and gentlemen, I am going to spare you a clause by clause breakdown of the bill. I'm not going to take you through it section by section, subsection by subsection, subparagraph by subparagraph, or schedule by schedule. Rather, I thought it was perhaps apposite to actually just talk about my general impressions on this, or what it's going to mean, how it may or may not pan out in some respects, and I'm actually. Having read it, believe it or not, there are some green shoots of optimism that we maybe as a group, an HMO action group, be able to do something about some of it when it comes in. I mean, the first thing to say that this bill is an absolute potpourri of measures cobbled together from various strands of policies, ideas, proposals for reform that have been knocking about in some cases for a decade or more. And of course, we forget that this originally was saw its legislative process begin with the Renters Reform Bill under the previous Conservative government. And that process, well, they promised a number of these measures that we see in the Renters' Rights Bill. They began that in 2019. Now, admittedly, we did have COVID, but the progress in changing a system like this, our housing system, so far as it can be called a system, tends to be a lot slower than politicians anticipate, judging by previous reforms. I mean, what the jaw-dropping bit for me in the whole renters' rights bill was the cavalier way that assured short-hold tenancies are abolished after 36 years in one clause. Just they are this is the command economy mindset that imagines simply because you command it, it will happen. Now the problem is that behind stretching back that behind this, back to 1988, we didn't have short-hold tenancies haven't been around forever. They were introduced under the Housing Act 1988. And for 36 years in England and Wales, and to some extent in Scotland, a whole system, whole industries, whole sectors have been based around whether it's you thought it was a good thing or a bad thing, that has been the structure. And I can see where it comes from in government to think that they can abolish this at a stroke and start the whole new regime afresh, that this is going to be a revolutionary overthrow, and Angela Rayner will look forward to that meeting that they will have in the House of Commons, where it will be a big press conference and lots of people will be invited to cheer and welcome in the arrival of the renters reform, and they would like to all do it at once. And I really don't think that is going to be the case, because some parts of this bill are clearly going to be counterproductive. Some will not work at all. Some parts are wholly unnecessary. Some parts I don't think will ever be introduced, and some parts should have been strangled at birth. And what also weakened the introduction of this legislation, even if there's anyone out there who imagines it's a really good thing, it is a massive committee effort. It has involved civil servants, Treasury Council, and shifting ministers and politicians have all had their say over more than 5 years already. And those people have changed. The people who started this process off, many of them in the civil service, may now be long gone. And the disturbing thing is, substantial as this change is there is no controlling mind behind it. There is no single person who really knows what's going on. What there are sectors of politicians in the civil service, in DULAC, Department of Levelling Up Communities and Government, have all had their say and have their bit, but there is no joined up thinking. So my own view on this piece of legislation is that it is, although it has this aim of starting housing law, landlord and tenant relationships afresh, it's actually quite an unstable piece of legislation, because parts of it I just don't think will work or come to be, because it's already the product of a range of shifting political priorities, photo opportunities, reactions to sensationalized stories in the press. And if we go back to the Housing Act 1988, which it seeks to replace, well, the assured short-hold tenancy was brought in against a very different set of circumstances. At the time, there was an expanding economy. At the time, rent levels had not gone up. The year before, a whole system, which we still have today, called housing benefit was created to sustain it. Now, there has not been sufficient thinking, talk, or even preparation about what this legislation is going to mean in. I mean, if you announced it, what it would mean from the start. For heaven's sake, we don't even have enough housing lawyers in this country to properly interpret it and understand it, advise people, and rewrite contracts and letting agreements. We've had a shortage of housing lawyers for 20 years. People going through law school now do not go into housing as a choice. There is a shortage from a tenant point of view. London is bereft of housing lawyers available. It's going to, and your average solicitors, well, I mean, I dare say there's some who are looking at this who are just going to retire from the field because it is a monstrous piece of legislation in terms of its complexity. And again, it's a very different system, which I can see limping on for one reason that it won't be killed off immediately by members of parliament is that we now have far more members of parliament sitting in the House of Commons than we ever did in 1988, who are now landlords themselves. Now you might think, well, why don't they do something about it? But that is the truth. Real change, from one perspective, root and branch reform, if it was done seriously, would be very different. But there are vested interests at work. My own view since 2018 is that there is a drive in Parliament, and it's been certainly been clues there from 2016 in legislation, that there is an attitude against the independent landlord sector in England and Wales. That really the independent landlord is something which is to be rubbed out of existence eventually, or if they can't be rubbed out, they should be turned into companies. Now, that isn't my theory. This is not my conspiracy theory of the world. This was announced at the Landlord Investment Show by the online property consultant and editor for the Daily Mail, who, looking at the whole thrust of housing legislation, has basically said, really, they don't want independent landlords like the people who are making up the audience. And that would explain the huge regulatory burdens that have been piled on individual landlords since 2016 in different forms of legislation. Now,
Now, Alan,
it
can
may
I
be,
can I can I just cut across you there because I'm
please,
conscious a little bit about time. Um,
yeah,
it's really good to know that context. I think it's very important that we remind ourselves of that context. What I'd like to ask you, pick your brains a little bit as a specialist,
mhm,
is with regard specifically to the Renters' Rights Bill, where are we in the process? Because I think one of the things that we as a group, we as a, tonight on this session need to know is there a point still in making our views known? Where are we in the progress of the bill towards it becoming law? How far are we away from that happening? And what do you see as being the opportunities that we might not have grasped as quickly as we wanted to, because it came in very, very quickly with the Labour government, or certainly the initial Green Paper did. What now for this bill?
right. Well, I'm pleased to address and give you my views on that, Wendy. First of all, it's swept through the Commons. It's swept through, in particular, it's gone through its first reading, its second reading, and it's gone through the committee stage with remarkably little alteration. Um, and it's clearly being driven, and it's gone on to the report stage. It's reached the Lords now. The latest version available of the bill is the Lords. Now, members of the House of Lords will have an opportunity to correct it. There'll be a report stage. It will go back eventually to the Commons sometime in the new year. And even at that late stage, members of Parliament, if sufficiently brief, could step in and propose amendments or alterations. But thereafter, it would go for royal assent. But that's not the end of the story, because and this gives me some confidence and actually a reason for the existence of an effective HMO lobby group, is that tucked away in the clause is a remarkable power which is given unto the Secretary of State, and that is effectively to be able to rewrite parts of the Act, parts of create regulations, and even to rewrite existing acts of Parliament, other legislation, in order to further the purposes of the Act. So, and it's really the same situation as we had over the council tax. When it came to it, Michael Gove, who was able to change the law on HMOs and their council tax position, or at least clarify the law and make it, had the power to do it. Now, he'd had the power all along. In fact, successive secretaries of state, going back as long ago as the Local Government Finance Act 1988, had that power. Now, problem is ministers aren't going to know this necessarily. The new unhappy lords don't necessarily understand their full range of powers. They tend to believe civil servants who may be driven by their own agendas. But this is where it's important to have an independent, informed um, sector to be able to take any concerns that exist, and there will be many things which crop up. There is a route by getting direct to the minister to be able to change substantial parts of the Act, even when it becomes law, or at least affect it. Now, looking at different parts of it, you've mentioned the ombudsman. What hasn't been stressed is you don't have to get involved with the ombudsman. There is still the right to go to court, or still the right to go to a tribunal. um, that could actually quash intervention by the ombudsman. If anybody's had experiences with the ombudsman, I'll tell you two things. There's different forms of ombudsman. There's a local government social care ombudsman. There's a housing ombudsman. There's an energy ombudsman. The actual ombudsman is really a chief executive who just oversees the system. The actual decisions are made by not necessarily well informed or clued up caseworkers. They have a checklist of all the reasons why the ombudsman won't take a case or decide that it is not within their ballywick or jurisdiction. And there's a whole lot of grounds whereby an ombudsman may say, well, this isn't something we can deal with. What's not, I mean, it's all very well to say you have a right to go to the ombudsman. What they don't tell you is that the ombudsman has a discretion. Ombudsman can say, no, we're not going to take this. And they have a long list of reasons. What they can't do as the ombudsman is get involved with court proceedings. So that may be one route out of the ombudsman. Now never rush to court, but there could be issues there. But there could be a whole range of reasons why an ombudsman would not seek to act. The other thing is it does take an awfully long time to get through the ombudsman. What the legislation hasn't emphasised is all that it's a discretionary thing. Similarly, with the discrimination against people on universal credit. Now, frankly, we don't need more anti-discrimination laws. They're an absolute mess as we've got now, as becoming apparent in certain areas. We don't need more of them. But realistically, this isn't going to happen. It isn't going to happen because people on universal credit don't get paid enough, don't get enough by way of housing benefit to be able to afford rents in many areas. It's simply not going to happen because the rent will never be covered in the first place, unless universal credit goes up by at least 30%, which isn't going to happen. So there's whole things that look good on paper to certain viewpoints, but won't actually take place. We have proposals for a landlord register. We don't need any more registers. there's an existing HMO register. We have a massive national registry system called the Lands Registry. Heaven's sake, what's wrong with that? The thing is, you can bring in these wonderfully complex provisions, but every time you make it more complex, the number of people who can engage, and I'm not just talking landlords or tenants, but also in local government, in the civil service, in the legal profession, it becomes complicated for everybody else. And this is where I think the whole Achilles heel is yes, you can command a new Renters Reform Act. But who's going to do the basic work of redrafting all the documents? Who's going to rewrite the software on all the computer programs? Who's going to recalculate the benefit rate? There are just so many daily decisions where there is no provision yet. So that's one thing. So yes, I think when it starts to go wrong, the Secretary of State is going to need some organization, some informed people to go direct to him or her to say, this is what's got to be put right.
Yeah,
And it's going
yeah.
to need information. The second thing, the other good thing, is whatever this act does, and lawyers can sit around and argue about different terms and clauses endlessly. Whatever this act does, it doesn't actually abolish the common law, because this act takes effect within a framework of existing law. Because there's going to be a lot of people who don't even realise that assured short-hold tenancies have disappeared, in the same way as a lot of people with the 1988 changes didn't immediately realise that the old 1977 Rent Act provisions no longer applied. There'll be a lot of overlap. Now, in cases of uncertainty, then I'm pleased to say there are still some surviving bits of common law which will have to be applied, because you have to find a solution somehow. There's parts of the common law. I'm thinking particularly about the worries about antisocial tenants. Yes, if yes, there's these changes and grounds for eviction, but what about the tenant who's kicking off here right away? You can't, can't I hate to, this is again one of the problems is that we've got a long waiting list to get anything through the county court at the moment. But there are common law remedies and to some extent statutory remedies that you could apply here and now, that you needn't wait to go through the full ground eight processes, the whole part one of the Housing Act 1988. You can go for an injunction. You can bring proceedings against an antisocial tenant for private nuisance. People will be familiar with clauses that the person has quiet enjoyment. Well, you can enforce quiet enjoyment through the courts using common law. You can also, somebody raised the point about an antisocial tenant who causes the neighbours to cause problem. Well, should we dust off that antique concept of somebody being a public nuisance? Now, you can be pursued both in civil law and in private law. You can be sent to jail for being public nuisance. So if you've got an antisocial tenant who starts upsetting the neighbours, that there are remedies there. Now, these are the sort of things which I think the sector needs to be aware of. It's not a grim process that you can't do anything about. That's been shown already. It is possible even to change something as labyrinthine as the council tax system. I was touched you said I was an expert in council tax, but let me say I'm an expert in the sense I know how I don't know. I mean, the subject's so complicated, I have to look it up in my own book now. But there we are. But there are nonetheless provisions which exist in the law which give me cause for hope. So it's not overall a grim picture. This is why I think it's important. This is why I'm involved with this group. Is I think that the HMO sector, which has in many ways the closest relationship with its tenants, in many ways, and needs to manage their needs on a daily basis. Because if you weren't housing a great many people who are I don't know who would be outside what's left of social housing. I think there is hope here for if not obtaining substantial change. I don't think the Renters' Rights Act will be there forever. It will fall apart under the weight of its own iniquities, I think, and further legislation will be needed, probably within 3 or 4 years' time. But in the meantime, it's important that there is there is some central eye of the storm to look at the whole process and try and suggest ways and affect change to make a bad system at least work marginally better in the interests of everybody. Because the gains don't just go beyond landlord and tenant. These things can affect whole communities. They affect employment. They affect the wider social environment. That's why we need an
Well, that's
HMO
why we
sector.
exist, isn't it? Because we can see that bigger
Yeah.
picture, and we can see what's happening.
Sorry, that was a bit of a rant, but as I said, having been working my way clause by clause through this beast of a bill, yes, it is. Well, probably it's a bit like the Cyclops after it was blinded by Ulysses. It will thrash about and be a bit of objectionable, but I can see routes to escape off
Yes.
to the Isles of the Lotus Eaters, ultimately.
There is
Sorry,
light at
end of
the end of the
lecture.
tunnel. No, that's a
Yeah.
very good point to end on. And I agree, Alan. There's a lot of hope. There's lots of things to play for. So I'd like to wrap up this evening and say thank you to Alan. Thank you to Matt, who was here earlier. He's had to go for childcare duties. Well, we don't seem to have any questions. We've obviously blinded you with Renters' Rights Bill science tonight. So it's time for us all to say good evening, good night, and thank you very, very much for being here. And we really appreciate your input, your support of what we're doing, and we very much look forward to working with you moving forward.